Good morning, afternoon, evening. Not legal advice, just opinion. Don't rely upon anything. Do your own research. Really come to your own conclusions. Don't trust whatever anybody says, honestly. I was going to say about that is hope everybody is well, first of all. When I hear anything, my ear has a critical ear, unfortunately. So I hear it, but I don't accept it. And everybody should kind of have that same kind of ear because we don't know really what we're hearing, the accuracy, unless you know the source. So it's good to be somewhat skeptical, but it's also good to be open to the fact if you get information that is accurate. Now, before I go on for like 45 minutes, if anybody can hear this, please comment that you can hear this. And I'm going to wait 1 second before somebody does that as I'm looking. And hello, everybody out there. So I'm presuming that people can hear this, so I'm going to go forward. But we're going to talk about, obviously, Gtii in a way. We're going to talk about MMTLP briefly, and we're going to talk about Tesla briefly. Before we get started, I have three things I wanted to address, of course. Sayings or jokes, whatever you want to take, or purported jokes or purported sayings. If somebody told me this, if marriage is grand, then is divorce 10 grand? A friend of mine just told me that he got his credit card stolen, but he didn't report it. And I asked him, why did you not report it? And he said, because the thief was spending less per month than I was. And last but not least, and applies to me, of course, we're looking up the top of my head. Inflation is when you pay $50 for the $30 haircut that you used to pay $10 for when you used to have hair. So that's to put that in context. So going to talk about GTI and going to just jump to the forefront in terms of the current status, and then I'm going to go into some more detail, and we can talk about it then. So GTI, the court still has it under advisement. So when we appeared, which is about 10 days ago, I think 10 or 11 days ago, the court indicated, I don't remember the exact language, but the judge said to the effect that he would issue a fast ruling. Since then, I checked with counsel, and counsel indicates that he happens to have a very busy courtroom. And if I don't know if I indicated this, but I'm going to indicate it now. There's business courts in Nevada. So I think there are 5 judges who handle only business-related cases. He's one of them. There are trials in there, and they're very fact-specific. And so he's involved in a lot of cases, and he's busy. So I don't think you have to read anything into it either way that he hasn't ruled on it. But sometimes the way I think of it, and again, this is just pure speculation on my part, if you want to easily deny something, because I've had this happen to me before. I went in for a injunction once. The court granted a temporary restraining order in my favor, my client's favor, in a real estate matter. We went in for a hearing on a preliminary injunction. We had like a 2 or 3 hour hearing. I did most of the talking. The judge was really interested. He asked pertinent questions. And a few days later, I got the ruling. And the ruling was, after all that, one word, denied. So sometimes, if a judge wants to just straight out deny something, they can do quick order, denied. Doesn't require a lot of thought. Not saying that in this case, the judge could have done that, but perhaps they could. So you might draw the conclusion that if he hasn't he hasn't issued an order yet, it's because it might have more detail, which that's what I conclude. And I'll let it sit at that in terms of what the ruling is. I'm expecting a ruling any day. I did send out, and I checked this morning before I went on, of course, to see if a ruling had been issued. It still shows it as under advisement. That means, he hasn't issued the ruling yet. I did ask also counsel if they have any idea, updated time frame, and when I get some information about that, I will let you know. So that is that update as to now. Then I'm going to go into a bunch of detail. So I put that out for you, so you know the status. As soon as I get the ruling, I will let you know. Honestly, as soon as I get the ruling. So I'm going to briefly address two other subjects, then I'm going to go back to GTII because I have a lot of stuff I wanted to talk about that I thought is kind of interesting. Maybe you'll find it out interesting. Two quickies. I know MMTLP is going forward to those of you out there who know MMTLP. That's that famous stock that got U3 halted and has never settled. Almost, I think must be about 19, 20 months later. That's what got me interested in this stuff. And so there are legal proceedings ongoing, and the issues that seem to be currently being litigated relate to arbitration and FINRA arbitration. And there's obviously a lot of issue about the legitimacy of FINRA arbitration. I myself have been involved in more than one. And I got contacted by other counsel who had a problem with my particular arbiter and was wanting my input currently. So there are challenges to arbitration, I think, that are going to be occurring. It'll be interesting to see how it goes. It does take quite some time. Also, in those same matters, there were subpoenas that were issued. If, in fact, those subpoenas survive and are proper, let's assume they are proper. And let's assume, because I think I heard that Gary Gensler was subpoenaed, the current SEC chair. If, in fact, he's subpoenaed, and there was valid service on him, etc., most likely, if it was the appropriate circumstance and he actually was going to appear, they would work out something. If everything else, they're going to not appear. What they will do is, well, they will appear if it gets to that point in time, but most likely they'd file some type of motion to quash the subpoena in court, and they would argue why there's no need for him to appear. It's not relevant, it's not proper, somebody else could appear on his behalf and get the same information, a bunch of other things. And I don't know specifically the basis for the subpoena. I haven't seen it, haven't seen the request for documents, but I know that to the extent that any of these characters are subpoenaed outside of Congress, and that's the other thing, is that it might say that Congress has exclusive jurisdiction to handle supervision of regulatory matters, all kinds of nonsense like that, in my opinion. But anybody who's subpoenaed is going to object. So to the extent a subpoena is issued, expect that to be a prolonged process, and that's an MMTLP or in any matter. So you have to issue the subpoena, then there may be negotiations. There may be negotiations before the subpoena, and then there could be legal challenges, and then court hearings, and all kinds of things. So I expect that in MMTLP with regard to subpoenas, if they can survive, and we'll see if they survive. Obviously, I hope they can survive. So that's MMTLP. Tesla, briefly. Tesla, there was a hearing on ratification. There's a hearing on attorney's fees. It's with regard to the matter in Delaware about Elon's pay plan. It's under advisement, like our matter, although slightly different. And a transcript was just issued of the last hearing, which was about ratification by the shareholders. So the shareholders, after the court ruled in a particular way, went back and ratified the pay package that the court had basically thrown out. And so the issue that now remains is what effect that has on the underlying matter, and what effect it has on the judge's ruling. And so I was kind of reading expert views on it, and that, I put expert in quotation marks because who knows? It's again, I think a lot of it is just whole speculation. But they believe that the court's just going to let their current ruling stand, let it go up on appeal. I believe that any attorney fee award will be not what the plaintiff's attorneys originally requested. I think it'll be a much more modest award, but probably over and above what they should get anyway. So that's my view on that. And there's a Supreme Court case in Delaware about attorney's fees and how to calculate it that's pending. And that will probably have to be decided before you get a final ruling in that case, because there's an attorney's fee request by plaintiff's attorneys, the attorneys who brought the claim. for the shareholder that had 9 shares in the derivative action, which means for the benefit of the company, not for the benefit of any particular shareholder. So that's ongoing and moving on. 3, Alpine. So Alpine is still ongoing, and I checked again this morning to see the status of the appellate court. So we have ongoing matters we had 2 kind of proceedings. DTCC and SCC brought matters trying to get them kicked off their product line. And there was a stay, appears to be some kind of stay, but we don't know what's gone on. But there doesn't appear to have been any further action taken by the administrative agencies, and no appeals of that. And then there's the proceeding on appeal about, again, I think this is kind of a joke whenever I use the language, the expedited expulsion of Alpine after 40 years, and after, we're now on like a year of this proceeding. So we're waiting for the appellate court to say whether the expedited expulsion proceeding can go forward. And the FINRA has decided and elected not to go forward in federal court, which they could have, and we're waiting for that. So that Alpine stuff relates to people that have interest in, because some people believe that because of Alpine having a concentrated short position, that if they're forced to cover or go out of business, that would have some effect on the GTI stock. I don't know if that's true. Whatever I say, I don't presume that at all. And I don't know if it changes, because we all know that now GTII has been dropped down to the expert market. If you recall, they were OTCC, and in April of 2023, they were bounced down one level. I call it as a downlisting. I don't even know if it's a word, but they downlisted from, let's say, OTC. There's a top level, a second level. So they went from the second level to the third level, which was the pink sheet level, which we all could trade, all of us shareholders. When they weren't able to file their filings, apparently, as it appears, they then got downlisted one more time to the expert market, and that is limited. So all of us peons don't have, or at least most of us peons, don't have access to that market. So we really can't do anything. So for all intents and purposes, it's out of our control. And I see it's still traded, but volume looks very small. And if there was millions and hundreds of millions of shares, it doesn't appear like that number of shares is trading. And hopefully that situation will change. So I kind of looked at that, and the excuse that has been provided in part for not filing was because of the auditor that they had chosen. And if you recall, just to bring it to everybody's attention, and before I get there, I just thought this was humorous. And I may break this into 2 parts, because there's a lot of information. So I may do like half and half as I'm looking at this. So I looked at this. This relates to GTII. And this is what they describe themselves as. And I found this just, I'll let you decide if you think this is accurate. Global Tech provides the protective umbrella of a publicly listed and fully compliant SEC audited company to acquisition candidates. We can deliver the means through incubation for private companies to become public entities in good standing. I saw that and I thought, interesting, especially in that they didn't file their filings. At least that's what they say. So it's interesting that they say that, and they still claim to be compliant and a vehicle. And, I found it interesting that they're still maintaining that. I also found it interesting. So this gets to the point. So they now are asserting the reason they're not compliant. I think the reason they're not compliant, and this is my view, my take on what they're claiming, although it's not really clear, is because the auditor goofed. The auditor did their financials for 2022 and 2023, and when they were yanked out, the auditor, they had to re-audit the financials. They hired a new company, and that's delayed the delayed things, obviously, the compliance with the filing requirements. So I found it interesting. So, I'm involved in my own proceeding for defamation, and that's the part I think I'm going to leave for a later time. But because truth is a defense, and let me give you the elements, and then it'll make sense. So defamation. What is defamation in California? And these are a bunch of requirements. So these all have to be present to prove up defamation. That's libel or slander. One's spoken and one is written, although in the social media age, it's more what lasts longer, has more has more meaning than something that's fleeting. So what is defamation? The elements in California. It's a false statement, so it has to be a statement and has to be false of a purported fact. So it has to be a fact as opposed to opinion about you. It has to be about you. It can't be about generally. The statement has to be published. It has to be actually communicated to a third party, which is also interesting. So this is like the forest and the trees. So I don't have 400 million, like Mr. Beast. I would think he'd have a tough time claiming if he put up a video that someone didn't watch it. But somebody like me with a small channel and maybe in a long video, like this video might be today, it might be 30 minutes. So if I look at my stats, it's unlikely that all you guys, although you should, of course, and you should like and subscribe, of course, also, but it's unlikely that all you guys are going to watch all 30 minutes of you of the live stream. And if you do, are you going to hear my comments? Is it going to make sense to you? So anyway, it's kind of like if if a tree falls and there's nobody in the forest, does anybody hear it? If I put out a video and nobody watches it or nobody watches the part, is that public? Is that published? I'm just throwing out some thoughts because I'm going to get much more specific as we get much closer to the filing. And I will do another video about this, kind of making more sense of it. But that's kind of the issue of, we've all heard the defamation and libel, slander. So I'm kind of giving you now the elements of it. And it's a difficult claim usually to prove. So we talked about it. It's a false statement of a fact about you. So 3 different things. That's published, communicated to a third party. So that's 5 things. And that the person who made the statement, in this case, that would be me, did so negligently, recklessly, or intentionally. Now, what's the significance? So negligently, that would be like if I didn't do due diligence. So that would be like if I didn't hear from a bunch of people and then communicated directly with their counsel and then sent a bunch of emails and then looked at a bunch of documents and then spoke to other counsel. So, perhaps if I didn't do that, that wouldn't have been an adequate investigation. So normally, and again, I'm just doing a quickie here. Normally, if it's not a public figure, negligence is enough. But if it's a public figure, somebody who puts themselves out in the public, that's kind of interesting. So in this case, is a corporate CEO a public figure? Is somebody who lives at the Beverly Hills Hotel driving a Bentley a public figure? Is somebody who appears on TV a public figure? If they are, then as opposed to just proving negligence, you have to prove that it's done intentionally, that the person published this false statement intentionally knowing it was false. That's a very difficult hurdle to overcome. And then, of course, there has to be damage to the reputation of that party. So is there damage? So if you are like running a garbage company, and I'm just throwing this out, if you're running a garbage company, and somebody accuses you of running a garbage company, how much can your reputation be damaged? And the example I had is I had a jury trial, as it turns out, so I have some expertise in defamation. I represented a party. They were defendant. They made an accusation we had no evidence, real evidence, no direct evidence to prove that what we were claiming was true. So, and the allegation was of committing like an actual crime. So that made it per se. So that means that you don't even have to prove damages to prevail. But I was able to prove that they thought that what they said was true. And then as a result, damages were very, very minimal. And it was about a 10-day jury trial in LA. So I do have some experience in that area. Again, I wish I was not on the other side. But anyway, those are the elements of defamation. So what's interesting about that is we take it to the 10K that was filed in April of 2023. And I think this is important because the excuse for why they're not compliant today. In the 10K, signed apparently April 16th, 2023, David Reichman is referenced as the chairman of the board, chief executive officer, chief financial officer, and principal accounting officer. So why is that relevant? Well, in the prior auditor quit, I shouldn't say quit, did not renew their engagement. And that was effective early March of 2023. If you recall, January 25th, I believe, of 2023 is where that large number of shares was issued, which part of which in June of 2024 was canceled. So in March, the prior auditor they elected not to renew. They weren't terminated. They elected not to renew. And if you recall, they were replaced March of 2023 by Borgers. Borgers was that auditor that in or about May 3rd of 2024, the SEC squashed because they were a scam outfit doing fake audits, basically. And I think they looked at, to make that determination, I think they looked at about 1,500 audits they did or financials from 21, 2023. And after looking at that, they basically said that these guys were just, making up stuff, literally making up stuff. And they were terminated in May of 2024. So in March of 2023, they were hired by Gtii, and they lasted until after they were terminated in May of 2024. So, approximately 1 year. So what was interesting to me about that was David Reichman, who had run a tax and management practice, who I believe purports to be a tax expert, who spent time in high positions at American Express. And so tax expert, management, and then who held himself out to be the chief financial officer, chief executive officer, and the principal accounting officer. When they hired Borgers in March of 2023, how could they not know what Borgers was? A shill outfit. And if they didn't know, that's shame on them. That to me would be not doing their job. At least it seems like that. At least that would be my sense, that if Borgers had been publicly flogged repeatedly for misconduct, shouldn't you have known that? And then, since you were the chief accounting officer, chief financial officer, and chief executive officer with a tax background, when they were doing all their work product, shouldn't you have been involved, and shouldn't you have known not to use them? And if you had not used them, then, and used somebody who was legitimate, there would have been no need to re-audit the financials, right? Because that was a condition that the SEC placed on based upon the terrible work product of Borgers. So seems Seems interesting that somebody with a expertise in tax who held themselves out to be the principal accounting officer, chief financial officer, and chief executive officer would make the choice of Borgers and then would not recognize, or apparently would not recognize, or should have recognized what was going on. And again, if they had selected, I guess they said they selected a new auditor after Borgers, who they claim is legit. If they would have selected that auditor, and presuming there's no other issues with regard to Borgers, then we wouldn't be in this position, right? Because we would have been fully compliant. We wouldn't have been downlisted. And again, it seems odd to me that somebody with that expertise, why they wouldn't know. And then somebody who came in perhaps thereafter as a consultant to evaluate what was going on, who apparently also has expertise. It seems odd to me that they wouldn't pick that up also right away and be concerned, or at least check it out, especially in light of, odd stock transactions that eventually had to be canceled. So it seemed odd to me. So I took that and then I went back and I said, okay, I wouldn't really have known to look up Borgers because I'm not in the industry. But if I was in the industry, so if I was like a tax guy, well, if I like Tom Girardi, I know who Tom Girardi is. Tom Girardi is some guy who was married, an attorney who was married to the to one of the housewives of Beverly Hills, I guess. And he was a super successful plaintiff's attorney, but he ended up stealing a bunch of, apparently, because he's on trial, but he ended up apparently misappropriating client money, including from a plane crash, et cetera. And it's a lot of money. And he's on trial. And I know about that. I've heard about that. I don't know if everybody else has heard about that particular trial, but I have, because it's kind of my industry. And it's kind of a big deal because it's out there. Borgers seemed to be like they were doing a ton of audits, and that's kind of seems to be that's part of the problem, because their procedures were criticized. It seems like they did too much work, didn't have the controls in place, and that's why they were criticized. So it's again odd. It's odd to me, and I would like some kind of explanation why it wasn't detected by anybody. And remember, there's also a note on this form, on the signatures. Donald Gilbert is the audit chair. I don't know what audit he did, but if he did an audit of the filing, then I think we have a problem, because it's probably a bad audit if they had to re-audit that and if the SEC shut these people down. So I looked at that and I thought about it. Okay, so, how come, shouldn't you have known? And then I went back and I looked. So then I looked at, for example, just kind of looking at Borgers. So I took the question. The question was, if that was my business, how would I know? I mean, would I know? I mean, was it easy to know? And then I kind of looked through a bunch of filings, and there's basically a trade group that publishes reports, like inspect. So here's one, for example. So it says, I don't know if you can see that. Yeah, I don't think you can see that. Interesting. There we go. So it says 2021 BF Borgers CPA inspection. So this particular agency is the Public Company Accounting Oversight Board, PCAOB. And they regulate, my understanding is they regulate all the auditors. And they did a bunch of reports about Borgers. I think it went back to 2015. It may have been published later, but there's multiple reports, I think about 5 or 6 reports, and they all like rip the work product. So they talk about Borgers, and they cite their numerous deficiencies in their audits, and they cite in part their failure to do, adequate analysis, adequate research. And this is over many years. And then I don't have it in front of me. Then I saw in a particular year, there were a couple members of Borgers company that got personally either censured or terminated. Brady appears to be Brady Jensen, something in October of 2019, and then Bo Xing Lin in May of 2022. They both got sanctioned or censured. That's all before 2023. And then in January of 2024, the Canadian watchdog agency, so I gave you the PCAOB, CPAB banned Borgers. That's January of 2024. And nobody did anything until until May after the SEC acted. So despite that, nobody did anything. Then there was another association that dinged them also. So there were multiple filings. There was a Hindenburg report in 2020 about Ideanomics that had questions for Borgers and referred to another company called Predictive Something about questions about Borgers' work prior to that, which was 2019. This is all public. So this is like if I were going to hire Borgers to do a job and I didn't know anything about them and I wasn't an expert in the tax business and I wasn't a chief accounting officer and chief financial officer, but I wanted to find out this information, I could have done it in a second. And it kept on accumulating. So the last report, for example, I think that was the case. The last report that the PCAOB did on Borgers was the worst. So it progressively got worse. So it would be a case of we reviewed 8 audits. We just selected 8 audits. There might have been some criteria. All 8 of them were bad, or there were 8 problems, or there were 30 problems, and they might identify the problems. And usually there were very meaningful problems. How they counted the revenue, or there were significant problems. And then the next time they do an inspection, so the prior one they did 8, this time they did 10. Now there were 10 problems. It wasn't that they showed any improvement, but they weren't terminated. So again, the issue of why weren't they terminated if they were, starting in 2015, and it probably was before that actually it happened. Why? And this is kind of the question that we had in MMTLP. Why doesn't anybody act? Alpine, for example, as to GTI, has 45 years. I think it's 45 years of misconduct. So it's not 1, 2, 20, 50. It's like dozens of incidents of wrongdoing, and nobody acts. Why? There's no right. There's no God-given right to continue to act inappropriately. So when the PCAOB continually targeted Borgers, when the Canadian agency literally got rid of them, when there was a history of other incidents of being disciplined, why were they still in business? And then why would somebody who had an expertise in that area not know that? And why would they use them knowing that? And why are we in the position today that despite that comment I made about being fully compliant, remember I read that thing to you, and when I say that's current. That's what they claim. When they claim they're fully compliant, how could they make that claim? And again, if they would have chosen a competent auditor, wouldn't we not be having this discussion? And wouldn't we not be in the expert market? So that's where I'm going to leave it for today. I'm going to do another one about the defamation, because we're going to talk about those elements we talked about a little bit, and we're going to talk about opinion and fact, and we're going to talk about truth and those elements. And hopefully, when the next time I speak to you, I will have the ruling on the application in Nevada for the receiver and for a TRO. Hope we have that very short. In the meantime, just, do whatever you think is correct. I know it's very tricky. I know I don't have any access, nor am I going to sell them anyway, but I have no access to the expert market. I just see it. And I think I read from somebody else that there's not a great deal, at least in my view, there's not a great deal of reliability in that particular market. So be careful if you trade it, and trade with an open mind. Do your own research, of course. Don't rely upon anything I say. Do your own analysis. If you want to go look back up at Borgers, and might be an interesting exercise for people if they want to start learning how to read financials, is start reading, like go through the April 2023 10K and read it, and start analyzing, because it might do you some good in the future on another transaction where you have more familiarity with it, and it might make an impact. Last but not least, of course, remember that the reason we got downlisted again to the expert market was because they let it get downlisted to the pink sheet in April of 2023. And if you recall, the note that was published, and it's referenced, I think, either in a May 3rd or May 10th filing, 8K filing of 2023. The problem was it reflected reoccurring issues. And again, I don't believe anybody has disclosed what those reoccurring issues are. And certainly nobody's corrected those reoccurring issues. But if those issues had not existed, right, at that time, then even if there had been non-compliance and a downlisting, maybe it would have only been downlisted to pink sheet, as opposed to now where it's not available to any of us, or to most of us, other than, I think, broker-dealers and accredited investors. So I will, when I have more information, I'll bring you up to speed. Hopefully that brings you up to speed, and it gives you a little more idea of kind of how they dropped the ball with regard to Borgers, and how not just they, but everybody dropped the ball. Why didn't other people know that? Does that mean that others were trying to use Borgers for their own advantages? Because I would guess, you're usually not going to choose somebody who's going to give you bad numbers if you know that. So if they knew that Borgers would be helpful, was that going on? Were there, and I have no idea about this, none. So this is pure speculation. But was there compensation paid to Borgers to produce certain work product? And I don't mean just like they charge their fees, but were they paid monies outside of their fees to produce products in a particular way? Because you can't imagine that, again, can't imagine a company hiring a bogus company to provide a bad result. So when all these entities are audited, it'll be interesting to see how it results. I know in NextBridge, so I'm aware of NextBridge Hydrocarbons, which was the endpoint of MMTLP. They used Borgers. They terminated Borgers in February of 2022, and there was it's hard to tell what the reason was, even though there seemed to be some disagreement about whether they were a going concern or not, that reference, and they were terminated. When they and they just did 1 year as opposed to 2 years. And when they did a re-audit, there had to be a change in the assets of the company. And there was quite a dip in the asset. So one asset was recognized as, let's say, 90 million, and they completely wiped out the value. And that obviously affected the financial, and that was the re-audit. So I don't know how it's going to impact GTI when we get to that point in time. So I'm going to leave it at that. If you have any questions, comments, in the meantime, let me know. And because I'll post this, and if you want to comment or ask questions after the fact, I'll take a look at them and we'll respond to the extent I can. And obviously, as soon as I have a ruling, I will let you know. And I will also do, of course, I will do another live stream talking about the issue of the defamation action, because, and I'm going to leave you with this, because what's interesting about the defamation action, I think I kind of may have buried the lead a little bit here. But what's interesting about the defamation action, so we have an action in Nevada where GTI is a nominal defendant, means they're a defendant, but they're not the main player. They're just defendant because they're a derivative party, but they're not really the focus. There's directors that are the focus of the matter. But Mr. Rabari is not a defendant in that matter. So in California, if you recall, I filed an original action, which I dismissed when the Nevada action was filed, which will come up in our discussion about defamation. And the Nevada action was filed. So there's a lawsuit that was filed June 27th in Nevada. That's pending. That's the one where the receivership was pending. On or about July 2nd, a defamation action was filed against me here in Southern California. Now, they allege that they have proper jurisdiction now in federal court. They claim that despite what everybody has said, that David resides not at the Beverly Hills Hotel, but in New York. That's what he maintains. They put a declaration in. I don't know if it's true or not, but that's what it's claimed. And we'll find out. But so he sued. And then what happened is I graciously granted them some relief, graciously granted them some relief to correct an error they had made about something they didn't correctly allege. Instead of just doing that, they added claims from Mr. Rabari. So they added him as a plaintiff, and they added some claims. Now, up until that point in time, I couldn't go after Mr. Rabari because he wasn't in California. They could go against me in California because that's where I live. But Mr. Rabari doesn't live in California, so I couldn't pursue him in California. But once they assert claims against me in California, then I could assert related claims against those parties that made those claims. So, for example, if Mr. Rabari made claims that, even if they're false claims and even if he loses, if he basically said, I know I'm not, properly in this jurisdiction, but I'm now going to take advantage of this jurisdiction by filing the action here where the defendant is located. But once you do that, you open yourself up to a cross complaint. In other words, an action that I couldn't have filed before because I couldn't reach Mr. Rabari, he's now made himself available to me because he's asserted jurisdiction in California. So I've thought about, had counsel really thought that out? Because what happens if I decide to file a cross complaint against Rabari, challenging those 28 million shares and the contract he's been provided from Mr. Reichman and GTI? What happens now? Because now I have standing to do it because I could do it here in California. So couldn't I go ahead now and file an action in California against Rabari? And of course, I could do it against Reichman too, because he filed the defamation action. And couldn't I challenge all their compensation? That's what occurred to me. I haven't really thought it out beyond that. But it really, if I were in the shoes of plaintiff in my case, I might be concerned that I may have opened a door that I shouldn't have opened, because it might expose my plaintiff to stuff that they didn't explain or wasn't really thought out very well. But I may be wrong. That's just my thought. And I'll discuss it in more detail when we go through the defamation action and what my response is going to be. Obviously, I'm not giving you like 100% of what I'm going to do because apparently, and please like and subscribe if it's the lawyers from the other side who are watching these videos, because they've obviously watched the videos because they cited the videos in their complaint. But please, if you watch the videos, and your counsel for the defendant, please like and subscribe. That's all I can ask if you're going to watch. But what's going to happen is I'm going to be filing a response. I have till September 10th. That's the date by which my response to their first amended complaint is due. I will be filing a response, and I'm going to kind of be alluding to what I'm going to be doing until I do it. And then after I do it, then we're going to talk about it. And then I can be very specific because it'll be on file. But up until that point in time, I'm just going to kind of dance around it a little bit, but we're going to discuss the issues. And they're probably going to guess as to what we're going to do here. What are we going to do? And that's where I'm going to leave it. I'm going to leave it for today, and we'll address the next action. We'll address it when we get the ruling or before. So I'm going to leave it there, even though I said I was going to leave it there before, but I lied. Anyway, everybody be well. Have a great day. I'll keep you apprised when I hear a ruling. The case is going forward no matter what, no matter what the judge ends up ruling, and we'll have to see. Again, like I said, I thought he was a thoughtful judge. I had no criticisms yet about him, but he could change my mind depending how it goes. Again, the time frame for him not having ruled doesn't seem to be extraordinary. He's a busy guy, busy judge, and just unfortunately, there's a lot of matters, a lot of lawsuits in Nevada too, because it's a state that does encourage corporate filings. So as a result, you're going to have a lot more litigation there, just like you have a lot of litigation in Delaware or with Delaware entities. Anyway, I've been babbled on long enough. Everybody be well. Take care. Again, if you have any questions, when I post this, just post them in the comments and I will try to answer. And of course, I'll keep you apprised. Take care. Have a great day. Be well. And